Next, we have the Cpesaz case. Douglas Rubel appearing for appellants. Scott Gauthier appearing for appellee Fager, Drinker, Biddle, and Reith LLP. And Russell Clemenson appearing for appellee U.S. trustee.
Morning. All right, that's fine, sure. Quite all right.
Splitting my time and are going to run up here.
All right, okay.
Yeah. He doesn't have to run.
All right.
I'm just going to say that.
Okay, would you like to reserve some time for rebuttal?
Yeah, I'm going to reserve most of my time for rebuttal, Your Honor,
Okay.
maybe 10 minutes, because
Okay, that's fine.
there's two of them and there's one of me.
All right.
Your Honor, good morning.
Good morning.
I'm sorry to bring an attorney's fees case before you, Judge Taylor, for one of your last arguments and situations. I'll kind of skip the wind-up and get to the pitch. First thing, I filed a motion for permission to appear. I don't know that the court ruled on that. Mr. Johansson and Mr. McNutt, who have been representing the appellants before this panel in, well, two other matters, were unable to appear today. They send their apologies, and I'm here.
Well, it's granted. We haven't cut you off yet, so I think we'll let you keep
Well,
talking.
I figured as much, but I just wanted to tie that one
Go
up.
ahead.
I'll skip the pitch, okay, or the wind-up and get right to the pitch. We think the bankruptcy court didn't reduce the attorney's fees by enough.
Okay, well, how much would be enough? What's the formula that you think we should apply? What's the rule of law here?
Well, I don't know that there's a formula for you to apply. I think under these circumstances where the bankruptcy court didn't tell any of us the basis for her ruling.
When you say the basis, you mean she didn't identify line items in the bills that she was cutting out?
Among other things, yeah. She pointed out, okay, block billing, I'm going to take off $60,000 for this and $50,000 out of the second interim, and there's that amount for block billing. Yes, we don't know which line items. Now, I've been practicing mostly federal court-wise, not in the bankruptcy courts. I've been practicing for 30 years. You know that the billings that you send are, yeah, of course, winning the case is the most important thing. The second most important thing to your client is getting those bills because it's the communication, right? Insurance companies, very important to insurance companies. Courts, it's very important to courts to be able to review and to tell what was done, who you met with, why you met with them. There's a justification for all of your billings. We don't believe that there was sufficient billing judgment. We don't believe that anyone looked over the bills and questioned any of them. We think that the bankruptcy court, okay, the judge took off $261,000, keeping aside the $120,000 for the violation, and we don't appeal that. They haven't appealed it either. So we're dealing with $261,000 out of $3.7 million, which is, I don't know, I'm not good at math, 7-ish%.
About 15 if you include the 120,000. But anyway, I want to come back to the question I started with. How are we to know given the abuse of discretion standard of review, how are we to say it's too much? What's the principle we're supposed to say?
None of us know that without you and your collective wisdom.
We're not fact finders.
Huh?
We're not fact finding here.
So
what are we supposed to be
asking us
doing?
to sort of do again what the bankruptcy court did, right?
Well, it's an abuse of discretion for her not to have said exactly which line items that.
Well, I'm going to challenge that because there's a huge body of case law in the bankruptcy area that says it's not the job of the bankruptcy judge to go through on a line-by-line basis. It's your client's job to line out what needs to be taken off.
And we did.
She went through it presumably, and so we can presume that she looked at what you presented, and she made a determination that you'd been over-inclusive because she didn't do everything you asked her to do. So I'm trying. Going back to what Judge Ferris said, I think what we're struggling with here is what would you say? I mean, I know what you'd say. She should have done a 500-page memo. I'm only being slightly.
Only slightly.
Only
but
slightly.
Yes, I understand.
Saying every jot and tittle of what she did based on what you'd done, and I don't think that's the basis. And then what are we supposed to do? Certainly we're not supposed to do that. We have to weigh what she did. So what's the standard? How do we determine there's an abuse of discretion? Is the fact that she didn't show her work, is that what you're saying?
Yes, that's what I'm saying.
Okay.
I think it's required to show your work, and I think that this panel can take, the reason I came out here was to beg you to take 10 or 15 minutes and look at our appendices, and if you decide the only way you can view as to whether the judge abused her discretion without showing her work is the sense that you get collectively over looking at those bills for 15 minutes and determining that, hey, either she's right and the appellants are wrong here, or our sense is, there's a problem here.
But we did. Go ahead.
I'm sorry. No, you go ahead.
We didn't handle the case. How are we supposed to do that? I mean, I know one of the benefits of being on this panel is you also sit as a trial judge. And I know when I have something that's heavily litigated in front of me, I've got a pretty good idea of what that should cost. I know what the bills in the community look like. I know what bills in similar cases look like. There's no way we can substitute ourselves for her and that basis of knowledge. Or how do you suggest we do that?
I think the bills themselves and the improprieties in the bills, the way they're written up and the way they're submitted, especially under the local rules that require an explanation, a detailed explanation. The local rules, I don't believe, should be forgiven under those circumstances.
Well, they haven't been. She just came up with a number that you don't like, is the bottom line, isn't it?
No, I think the problem is she just came up with a number.
Yeah, but it's not as if she disregarded it. It's that there's a matter of degree here that you think is inappropriate, and how can we judge a matter of degree? Given the case after case after case tells us that the bankruptcy court has enormous discretion in reviewing fee applications, both because they watch the entire case as a whole and they know the arc of the case and the narrative of the case, and they know that in particular instances, some things were hard, some things were not so hard. I mean, we are told time and again to defer to that. So if it's a matter of degree, how do you propose we do that?
Only by looking at the bills.
Okay.
That's the only way you can.
And
The bills themselves give the arc of what happened.
And is she bound by the local rules? I thought the local rules bound attorneys.
I don't know the answer to that question, Your Honor.
I think she isn't. I know I'm not by mine. So,
I would assume that, if the local rules require me to be very detailed in what I'm doing, and I'm submitting that to the court, that you're going to pay mind to that local rule and the requirement, and you're going to want to enforce the local rule.
but she has discretion not to.
Let me
I
change
think-
the topic a little bit. You argued, and I've forgotten whether it's the appellate brief or the briefing below, that the law firm should be responsible for everything that your client said Mr. Paredes did wrong, simply because the law firm referred Mr. Paredes to the company for hiring. Is there a legal basis for that?
Yeah, I know our briefings, I apologize for the tone of our briefings, especially the reply in rereading that.
Well, you didn't write it,
If
presumably.
we had to do it over again, perhaps we would have done it in a different way. Look, the violation and the connections between between Faegre and Mr. Paredes, we didn't appeal the amount. The judge sanctioned Faegre and $120,000. Faegre has accepted that. Nobody has appealed that. We don't agree that it wasn't a problem, that it should be more. It's not really an issue here. It is to the extent that we argued below that the court could go above and beyond just the local rule type billing disputes and had her discretion to do more. We clearly disagree with the court's statement that 120 is is the amount I'm sanctioning you. And look, if I had known this way back when, we'd be in the same position we are now. No, I don't really think that's the case. I think something could have been done to put in a different ESOP trustee. It doesn't matter for purposes of this appeal. And yes, I'm asking you to please take 5 or 10 minutes and look at something that, how do we know how much to do? Where are the...
But you're not arguing about the 120.
I'm not arguing about the 120.
I mean, what the court found was, look, that's not an actual conflict, despite all your co-counsel's protestations that it was.
Well, I'm part
So
of the,
she
I'm
had
part of the co-counsel.
she had the discretion to do what she did, and she came up with 120, and you know that's just, let's just leave that on the side, okay? Let's not have that influence anything else today.
Look, my clients are, the residual estate. It's a $15 million estate that's estimated to be, I don't know, it's been the same for a year and a half now, so about $5 million now by the liquidating trustee. We've gone from a lot to 30 cents on the dollar. $5 million, I suspect it'll be less than that. That's just kind of the way things work. Obviously, my clients are unhappy with the situation. The first appeal, you know very well. There's another appeal that we're trying to resolve as we speak, and the court recently, the panel recently gave us until December 6th to file our opening brief in that matter. If we can resolve it, we will. Those phone calls are happening later today with the Ninth Circuit. No, we're not arguing about the 120,000 or Mr. Paredes. Not today.
Okay, we've cut well into your 10 minutes,
That's,
so
that's okay. Do you have any other questions?
we're good for now, I think.
Thank you very much.
And I understand you've agreed to divide your time. What's the deal you've struck?
Yes, Your Honor. I think that the U.S. trustee would like 2 minutes, so I'm going to try to do 13 minutes.
Okay.
And leave Mr. Clemens in 2 minutes just to address any issues that I don't think there are with respect to the conflict issue.
Great. Go ahead, please.
Good morning, Your Honor. Scott Gauthier. I'm with Faegre, Drinker, Biddle, and Brief. I'll seek to limit my comments, as I said. The panel should affirm the decision of the bankruptcy court uphold the award of attorney's fees and expenses in the amount of approximately $2.3 million. The evidence presented was more than sufficient to demonstrate that the services were actually performed, that they were necessary, and those were the challenges in the appellant's objections. There are other factors under 330A3 that the court is commanded to look at and did look at, but those were not challenged, so I won't go into that. Affirmance is clear in light of the highly deferential standard of review that's applicable to a bankruptcy court's review and ruling on a fee application. The applicable burdens and the evidence under consideration here, the context in which the court examined the evidence and objections at the time, and the attention that the court devoted to its ruling. Because the court is in the best position to determine the reasonableness and necessity of Faegre's work, it's in the best position to determine legal fees. As this panel has just noted, many courts, and I think In re Strand is a Ninth Circuit precedential value. Hence, the panel would only reverse the bankruptcy court's decision if it found no support in the record for the bankruptcy court's ruling, citing In re Cox at Ninth Circuit of 2011. The appellants don't dispute the deferential standard. The panel has said, so maybe I'll just move off from that. The Bankruptcy Code Section 330A authorizes the court to compensate professionals that are retained under 327. It requires the court to determine a couple of things. What services were actually performed, rendered, what services, whether they were necessary, and what compensation is reasonable. To supplement the court's knowledge, a professional seeking compensation, as this panel just noted, has requirements under Bankruptcy Rule 2016-1E, which supplements Federal Bankruptcy Rule 2016. If the professional fails to abide by any rules, this court has the same precedents, Film Ventures and Strand and other cases, that say that it is within the court's discretion to determine a sanction for that. And we can look at some
If
of...
it's discretionary, the local rules, for example, a deviation from the local rules is something the court can sanction for or not.
Correct. And these issues with lumping, these issues with block billing, those are certainly deviations. Now, there's two pieces to this, right? Because under 330A3, if the court can't determine what was done and can't determine whether something was reasonable or necessary because the vagueness of the application, and it's not just the vagueness of the individual time entries. The individual time entries is not the only thing that the court is commanded to look at. The court looks at the entire record. It has its own knowledge, firsthand knowledge, of the proceedings before it. It has the narrative of what work was done, and it can certainly think about how much time it would take to complete those tasks. It has knowledge as to whether or not those tasks were completed. The lawyers are commanded to use tenths of an hour to spell out exactly what they do. But as this panel has just noted, there's no mathematical formula in 330A3 or 330 that the bankruptcy court is required to apply. It doesn't have to say, I'm looking at this time entry. It doesn't have to have a calculator. And I think all the bankruptcy judges would hate you if this panel were to say, no, you have to add up each time entry and put a check mark next to it. That's not what bankruptcy courts are required to do under 330. They are required to look at all of these factors and determine how much time they felt was spent, what were the rates reasonable, was the work reasonable and necessary. That's exactly what the bankruptcy court did.
Let me ask you a question. Because
Yes, Your Honor.
So we've got, I'm putting on my trial judge hat, I've got a fee application in front of me, I've got an objection with very specific things. Is it error to look at the specific things and say, yes, I note they're there, but I look at this and in my judgment, based on my knowledge of the case, I think that's a fair fee? You have to, once given, if given a line-by-line critique, do you have to use it?
No, you have to consider the rates charged. You have to consider under 330. 330A3 uses the word shall. So there are 6 factors that you have to consider. But 330 does not require a mathematical formula. So having considered the time spent...
it does in the broadest sense, right? There's the lodestar. So in the broadest sense, it is a mathematical formula. But I think the question, which I also find very intriguing, is what's the connection between the judge's experience of the case, which is always the fallback, and the particular, I mean, the entries are sort of evidentiary, right? We're showing you what the time was. And there's a disconnect there somewhere between the judge's overall sense of things, especially in a large case with a lot of entries and a lot of time and a lot of fees, and the evidence. And the question is, the judge is, I think, entitled at some point to look at this, begin with that overall sense, and then critique it from the other end on sort of an evidentiary basis, but not necessarily go down to, point 1, point 2. Is that fair?
Yes, Your Honor.
Okay.
I think that's clear.
Well, I mean, amplify that for me. I mean,
there are thousands of phone calls, right?
Yeah.
In particular, when you're dealing with a sale and various attorneys that are making phone calls. Mm-hmm. Even if I detail each and every phone call, the importance of one phone call over another is not going to be apparent to anyone. However, it gives the court a general sense of how much time I spent on the phone.
That's the actual.
Much time I spent.
Okay, that's the actual necessary part.
So,
but on a block billing part, I mean, is it your contention that the judge is entitled to look at that and say, well, I can't break it out, but this is a fair reduction based on something?
Correct, Your Honor.
Okay, what is the something on which it's based?
In the Welsh case, which was cited and these are not precedential, and they're BAP opinions in any event, but if you look at Demas, if you look at Thomas, there are cases about, and appellants didn't cite it here, but there's a California Bar Association study saying, well, if you look at block billing and you look at lumping, that it may inflate fees by anywhere from 5 to 30%. Right. And so taking a reduction somewhere in that 5 to 30% is well within the court's discretion. Here, if you look at what was termed by appellants as block billing and lumping, it adds up to $570,000. We were penalized $290,000 for block billing and lumping. That's over 50%. If anything, Faegre Drinker would be the firm, I think, that would be complaining about the court's abuse of discretion, not the appellants here. The appellants want all block billing and all lumping or all vagueness to be penalized. And certainly this court's the precedent in Welsh, and this court's, the way this court has viewed that in the past, I think had we appealed the decision, the court may have found the bankruptcy court abused its discretion by reducing the bills by too much for vagueness and block billing. But
So teasing that out and
we're not appealing.
I understand you're not, but to the extent they have other concerns, is it fair? Would it be fair? You should listen to this. Would it be fair to say she may have over penalized here? So to the extent you have other concerns, they're addressed. And again, it's this rough justice of there is no formula. It's what the judge thinks is within the fair range, given her experience with the court.
The appellants here categorized various, other than block billing and vagueness. They categorized relief abandoned by the debtor, right, on the curve. The court clearly found, and the court in Appendix 4, I think page 24, lines 15 through 25, and the top of page 25, talked about all these categorical assessments and rejected all the categorical assessments. And she did so quickly because all these categorical assessments that the appellants had made had absolutely no legal basis. They cited no case law with respect to them, and they were nonsensical. For example, relief abandoned by the debtor on the Kurt motion said we shouldn't have been compensated for it. It's a categorical assessment, and the judge said, no, there's no basis for that. Interteam communications, they said that because we had more than one attorney working on something or more than one attorney talking to each other, and they added up, they said it was 10% of all the time spent on the case. Well, I'm thinking about it as a partner. I'm thinking, if my team members are only talking about this case and discussing things 10% of the time, we may need to have more meetings, because this was a case that, not by necessity, involved many lawyers, and I think communication between those lawyers is actually needed. 10% there's no evidence, and there's no reports, there was no study, there was no anything. It was just an assertion that how could we spend 10% of the time talking to each other?
Was that 10% included in some of the block billing too?
No, this was different. This was another $300,000 that they thought should be taken off.
Not included, no overlap.
Travel time. This court has found that it's within the bankruptcy court's discretion as to whether or not to award travel time. We had $15,000 worth of travel time during COVID in a case that was in Arizona. We had lawyers in Texas. Anyway, the court used her discretion there. Appellants' inquiries of the debtor. When their people had inquiries of the debtor or of counsel, they argue that we should have answered those for free. How could we possibly bill for responding to their questions? $24,000. The court felt the category this time was compensable. Negotiating plan and other relief, $207,000. Appellants argued below that we were correcting mistakes, that if we gave in, if we compromised in negotiations and changed the plan, that was correction, that was a recognition that we'd made mistakes. I assure this panel, Faegre Drinker did not make any mistakes. We may have negotiated, we may have made compromises to make things easier, we may have changed language. We were compensated for doing so and working with them. And again, the court found, and she need not spend a lot of time on ridiculous arguments, but she had said, these categories that you've identified, I don't find that they're per se non-compensable. And so I think the judge gave as much detail as she needed to give with respect to
that. You just answered the question, but I'm going to ask it again anyway. So his argument is she didn't show her work. Your response would be she did. In this place,
make an argument that Faegre Drinker shouldn't be compensated for $207,000 worth of time that it compromised and negotiated, with no citation to any case law, with no studies, with no compelling argument, but it's just your feeling. How much time should a bankruptcy judge have to spend explaining to you that your ideas are half-baked. How much time did the bankruptcy court in this case spend in many, many hearings explaining to these appellants that how much time did we have to spend? How much has this case cost? How much is that because of those types of legal assertions that have no basis in the record, no factual basis, no legal basis? How much time are we spending here today? I'll reserve the rest of the
All
time.
but 2 minutes, but great timing.
May it please the court, Russell Clemenson appearing on behalf of the U.S. trustee. I think my comments are necessarily brief. My colleague and I agreed that I would address the conflicts issue to the extent it still is a live issue today. I think the appellant has affirmatively waived it in oral argument this morning. I think the court has said it's really not before it anymore. So unless the court has questions, I will submit.
I don't have any.
I don't, thank you.
No.
Thank you, Your Honors.
Thank you.
Mr. Rubel, you've got about 4 minutes, not quite.
Just 2 minutes. It's a little bit arrogant of Faegre to say that what the ESOP participants have done below was inappropriate and improper without the efforts of the ESOP participants and their counsel. We are not being paid for this, okay? Without the efforts of them, those fees wouldn't have been reduced by $381,000. Without the efforts of them, the $120,000 sanction wouldn't have been put in place. And the entirety of all those conflicts and what had happened and the failure of Faegre to bring that before the court appropriately at the time would never have been raised. Faegre didn't do it. The ESOP trustee didn't do it, and I apologize for my frustration with the ESOP trustee. We obviously have a difference of opinion. He didn't do it either. It was us that did it.
All right, and that's fine, and healthy chagrin is a good thing, but that's not really what we're here about.
We had a legal basis to bring every argument we brought below. The KERP thing, okay, there's case law. If you prepare something and you weren't intending to file it or deal with it, you shouldn't get paid for it. Court found otherwise. Okay, that's fine. And with respect to, well, that's just a small issue that was raised by the court. It was easy to pick off certain little things. Now, I don't think the court at any time during this whole issue said, you know, I think $3.4 million is an appropriate fee. What the court did was she looked at the billings and she said, these are inappropriate, and here's why. Do I think there should be a line item? I think there should be more than what happened. And I don't know how to deal with the situation, honestly. You know, were I in your shoes, never will be. Were I in your shoes, I'd look at the billings. If I think there's a problem here, I think there's a problem here. If not, there isn't. Can we come back, Mr. Rubel, and say, you know, the 261 might have been too much? They didn't appeal anything. We're not asking for relief in that regard. Can you...
Doesn't it factor in? I mean, his argument, if we think 261...
Did I open the door to that? Yeah, I've been worried about that for some time. Absolutely. Yes. I don't think you're going to find that. I don't think anybody could find that. But is that a possibility? I suppose legally, yeah. I suppose it is, given what we're asking. But I just don't think the bankruptcy court did enough, that's all. She didn't provide her work. I think more was needed. I appreciate your time, unless you have any questions.
Further questions? Okay, thank you very much. The matter is submitted.
Thank you.
And court's in recess.